Hello, my name's Deborah Fosbrook and I'm co-author of the Contract and Copyright Drafting Skills published by Bloomsbury. And today I'm going to give you a little insight into drafting indemnity clauses. So the first thing you have to understand is, well, if you've never seen an indemnity clause, what actually is an indemnity clause and why is it given that title? They quite commonly appear in lots of different sorts of contracts, whether they're to do with your mobile phone or whether they're to do with product placement agreements or exploitation of rights. Quite often people put indemnity clauses and they look as if they're very much standard, they can't be changed, and you know, you've got to give your indemnity to someone else and they don't give one to you. Well, the first thing to realise is that indemnity clauses can be drafted in lots and lots of different ways. And that if you see one in a contract and you're asked to give an indemnity to someone else, you should be on red alert. Because basically what you're doing by giving an indemnity is giving an undertaking to somebody else to cover any losses and damages for the scope that arises in the future in relation to that indemnity. So the purpose of an indemnity is to make you liable to, so for instance, if I'm a copyright owner of a book or a product or some other thing or a film, and I'm giving you a license, within that license you will find an indemnity. Now, from a licensor, I own the copyright, to you the licensee, you would expect that I would give you an indemnity to the licensee and you would not have to give me one back. But quite often you can get two indemnities going on. So I'm giving you an indemnity in relation to certain clauses within the agreement, but you're giving me an indemnity in relation to other clauses in the agreement, which may relate to payment and payment of royalties in the future. So you've got to understand the use to which an indemnity is put. How indemnities are drafted. If I'm drafting an indemnity, I'm looking at it and I'm either trying to draft it as narrowly as possible so that I'm not liable to pay you any money in the future, or I'm trying to draft it as widely as possible. If you want to draft an indemnity very narrowly, what you do is you limit the indemnity. First of all, you try and get the indemnity removed. You don't even have an indemnity in the contract. You say, well, actually, I'm not giving you indemnity. Why don't you cover yourself by an insurance policy? Secondly, you then draft the clause so that it only relates not to the whole agreement, but to certain clauses within the agreement. So you may say, yes, I'll give you an indemnity for clauses 2, 3 and 4, but I'm not giving you an indemnity to all the other 150 clauses in the agreement. So you may limit it to ownership and title of the material, you may limit it to clearance costs, you may limit it very, very specifically. So you can limit it by the number of clauses to which an indemnity refers. You can limit it by the period in which the indemnity applies. In other words, the period, if say for instance the indemnity starts at the date of the agreement, well you say this clause will only run for either the length of the agreement, which may be the license period, or it may only run for 2 years. So I'm giving you a 2-year indemnity. After that period, I'm not giving you any indemnity at all. So that's another way of looking at it. You can then also limit indemnity in relation to different territories. So you say, yes, well, the indemnity will apply in the United Kingdom, the indemnity will apply within certain English-speaking countries, but I'm specifically excluding a whole variety of countries for which I'm not accepting any responsibility whatsoever. So you've got to understand that you can play with the clause, you can adapt it and use it to your advantage, and you know, it's worth making the effort to change the clause to reduce potential liability and risk. Who should give an indemnity? Well, you know, if there's 3 or 4, there's a consortium within an agreement, well, every single person within that, every single company within that agreement could give an indemnity either to all the others or just, you know, from A to B and B to C. The point is that the indemnity clauses which each company is providing don't have to be the same. They don't have to be the same in terms of the subject matter, they don't have to be the same in terms of the period that they run, they don't have to be the same in terms of the scope of the indemnity, and they don't have to be the same in terms of whether or not the liability is capped. So, you know, I'm a big advocate of the fact that you should limit liability. You actually put a fixed limit beyond which you're not going to be liable. So you may say, for instance, you may argue, for instance, well, we're only paying you £10,000, so let's limit the liability to something in relation to the value of the contract. So that's one part of it. The other aspect of indemnity is the process, again, by which a company relies making a claim under the indemnity. So here again, you've got to put very practical sub-elements to the indemnity, which basically force the person or the company relying on a claim under the indemnity to be very specific, so that you require them to give notice of the claim as soon as possible. You require them to specify the detail of the claim. You would, if you're the person who's going to have to pay out under the indemnity, you want the right to assume control of the claim, to refuse to let the other party settle the matter without your consent. So there's that aspect of it. Then another aspect which is relevant to indemnity is you can draft indemnities very widely, so that indemnity applies to direct and indirect consequences of breach of the whole agreement or certain clauses. If you don't exclude indirect consequences, you could be liable for costs and expenses which relate to third parties, which relate to marketing costs, which relate to recall of a product. So there's very serious financial consequences by allowing somebody to include in an indemnity clause direct and indirect consequences. So, you know, if you're drafting it, you try and restrict that. In the same way that you try and restrict also any claim being responsible for unlimited legal costs. So quite a lot of people put in, you know, will only be responsible for reasonable legal costs. But there's whole other elements that you may want to exclude from indemnity, and that may apply to third-party costs, administration costs, travel costs, all sorts of different sums which get incurred when there's litigation, which are not directly involved with just legal costs. So it may include accountants, other professional advisors, different elements like that. So an indemnity clause is very, very important in terms of actually taking the time to restrict it if you need to, if you're the person who's going to be claimed against. And if you're not, and you are seeking an indemnity from someone else, you know, you make that clause as wide as possible. The other issue in relation to indemnity is the duration of the indemnity, which I mentioned before. So if you want to reduce the time, you could limit the indemnity for the duration of the agreement. You could allow the indemnity to run for maybe 1 year after the termination or the end of the agreement, or you could make it even shorter than that. So that's another element as to what liability continues in relation to that indemnity after a contract has come to an end. So I think, you know, it's a topic that's worth making a lot of effort when you're, you know, when you're getting to an end of a contract and you think, oh, there's indemnities, you know, they're quite standard. Just don't accept it as that, and really take the time to draft something which is really to your advantage, because the financial consequences at a later date, when there isn't a claim under indemnity, can be very, very severe.